Welcome to Let's Talk U.S. Immigration. Here is a hard truth and a hopeful one in the same breath. Overstaying your welcome in the United States is one of the most serious and lasting mistakes a visitor can make, and yet it is almost entirely preventable. Almost nobody who overstays ever meant to. They misread a date, they trusted bad advice, they hit an emergency, and they crossed a line they did not know was there. Today, we are going to make sure that is never you by explaining calmly and clearly what overstaying actually is, what it does to your visa and your future, the specific traps that catch good people, and the simple habits that keep you and your family safe. Before we begin, everything you are about to hear is designed to inform and educate. Immigration law is complex, and every case is different. What you learn here should always be discussed with a qualified immigration attorney before you take any steps. We are the AI hosts for this series, walking through research carried out on behalf of the team at the law offices of Chris M. Ingram.
Right.
So if your heart just skipped a beat hearing that opening, you aren't alone, right? Immigration law has this immense heavy gravity to it.
Oh, absolutely.
It really feels like one wrong move and, a steel door just slams shut on your life or your career or your family.
Yeah.
But the legal research from our attorneys reveals something that's actually, incredibly empowering.
It really is.
Because that steel door is almost entirely operated by just a lack of information.
Mm-hmm.
It's not malicious intent that traps people. It is the invisible mechanics of the system operating in the background. So today, our mission is taking the anxiety out of those mechanics and, replacing it with armor. We're going to map out exactly how this machine works so you can navigate it with total confidence.
I love that. That is really the perfect mindset to have for this deep dive, because when you look at the case law and the statutes we're reviewing today, you realize the system is basically built on a series of tripwires.
Yeah, tripwires.
Right. And what's fascinating here is the danger doesn't lie in the fact that the tripwires exist. The danger lies in the fact that most travelers are walking through the room completely blindfolded.
Yeah.
They assume, logic dictates the rules. But immigration law is not intuitive at all. It is highly, highly mechanical. So our goal today is to take the blindfold off.
Exactly.
We are going to examine the specific dates that govern your legal existence in the U.S., the silent legal triggers that activate when you cross a boundary, and of course, the strategies that keep those tripwires from ever being touched.
And I want to start exactly there with this idea of a fundamental misunderstanding. Because, society kind of trains us to hear the word overstay and picture someone sneaking around in the shadows.
Right, actively dodging the authorities.
Exactly. But the reality is that the vast majority of these cases begin right out in the open, with a traveler holding their own passport, looking right at their paperwork, and simply misunderstanding what they're actually looking at.
Yeah, they're looking at the wrong thing.
Right. Okay, let's unpack this with a classic movie theater problem.
Okay, let's hear it.
So think of your visa like a movie theater ticket. You buy it at the box office and it gets you up to the door. It allows you to ask the usher to come inside. But the I-94 admit until date is the usher telling you exactly what time the movie ends and when you must leave the building.
That's it perfectly. It's the most crucial distinction in all of U.S. immigration law. And honestly, a failure to understand that distinction is ground zero for almost every accidental overstay.
So break that down for us. What are the actual mechanics here?
Well, we need to look at these two entirely different documents, which are issued by two entirely different government agencies. So first, you have the visa.
Right, the stamp and the passport.
Exactly.
Yeah.
Visas are issued by the U.S. Department of State, usually at an embassy or a consulate in your home country. And its only legal function, its only purpose is to grant you permission to travel to a U.S. port of entry and request admission. That is it.
Wait, okay. So if I have a B1, B2 tourist visa stamped on my passport, and it clearly says, valid from 2024 to 2030.
The 3-year visa?
Right, that 10-year window just means I have a 10-year window to ask to come inside.
Precisely. It is a travel document, not a residency document. But, human nature makes us look at that official foil stamp in our passport. We see a date a decade into the future, and we feel this profound sense of security.
Of course we do. It's right there in print.
Right. But the trap is sprung when you actually arrive at the airport. At that point, jurisdiction shifts entirely from the Department of State to Customs and Border Protection, CBP.
Oh, okay. The guys at the booths.
Exactly. The CBP officer at the booth examines your visa, asks you a few questions about your trip, and then creates an entirely new, separate legal record called the I-94.
And the I-94 is the usher in our analogy.
Right. The I-94 is your official record of admission, and on that digital record is a specific data point called the admit until date. So the officer might see your 10-year visa, but they will generate an I-94 that says you are admitted until, say, October 15th of this year.
Okay, so a few months.
Right. And the moment you step away from that booth and enter the United States, your 10-year visa essentially goes dormant. The I-94 admit until date is now the absolute singular law of your existence in the country.
The only date that matters.
The only one. If October 15th comes and goes and you are still physically inside the United States on October 16th, you are an overstayer.
Even if my passport has a giant shiny stamp that says 2034.
Even then, it does not matter.
That's wild. It feels like such a setup.
It does, and to complicate the mechanics slightly, because, the law is never perfectly uniform, not everyone even gets a hard calendar date.
Wait, what do you mean? Who doesn't get a date?
Well, if you enter as a tourist or on a business trip, you get a specific date. But if you enter as a student on an F1 visa or an exchange visitor on a J1 visa, the officer might just write DS on your I-94.
DS.
Yeah, which stands for duration of status.
Okay, wait. Duration of status. That sounds like a blank check. If there is no hard date on the I-94, how does a student ever overstay?
Yeah, people think that, but it is definitely not a blank check. It is a conditional admission. Duration of status means you are legally allowed to remain in the U.S. for exactly as long as you are actively fulfilling the purpose of your visa.
Oh, I see.
So for a student, that means going to class, maintaining a full course load, and keeping your SEVIS record active with your university. The date you must leave is tied to the completion of your academic program, plus a designated grace period.
Which is how long, usually?
Usually 60 days for F1 students. So if you drop out or if you graduate and that grace period expires, your duration of status just ends.
Wow. That distinction is terrifying, honestly, because it relies completely on the traveler's active awareness of their own situation. You can't just, look at a calendar on the wall. You have to know the specific rules of your category.
Have to be hyper aware, yeah.
But let's bring it back to the standard traveler for a second. The person with a hard calendar date on their I-94, they're visiting. Maybe they lose track of time, or maybe their flight gets canceled because of a storm and they stay one single day past their advisvo. Admit until date.
Just one day.
Just one day. What is the immediate real-world consequence the morning after that deadline passes?
So what happens the moment that invisible I-94 deadline passes? The immediate consequence is basically a silent, bureaucratic execution of your visa.
Execution.
Yes. We are talking about Section 222G of the Immigration and Nationality Act. Under this specific provision, the absolute instant you remain in the United States past your authorized stay, even by a single day, your visa is automatically voided. An operation of law.
Okay, I need to stop you there.
Yeah.
Voided by operation of law. Like, there's no due process, no judge looks at it, no CBP officer flags your file and sends a warning letter in the mail.
None. Zero. The law is written to be entirely self-executing. The trigger is literally the clock striking midnight on your admit until date. If you are still here, the visa that you spent months applying for, that you paid fees for, that you interviewed for, it simply ceases to be a valid travel document.
Just gone.
Just gone. And the most dangerous part of 222G is its invisibility. The physical foil stamp in your passport remains perfectly intact. It looks totally normal. You have no idea it is dead until you try to use it again.
Here's where it gets really interesting. Let's play that out practically. Say I overstayed by 3 days. I went home, thought absolutely nothing of it. 6 months later, I book a flight to New York for a vacation. I have my passport. I have the physical visa stamp that says it's valid until 2034. I get on the plane. What actually happens when I land at JFK?
Well, you walk up to the CBP booth, you hand them your passport, and the officer scans it. Their screen will instantly flag that on your previous trip, your departure date was after your I-94 admit until date.
Okay.
And because of 222G, the officer knows your visa is legally void. You will be pulled out of the normal line and taken to secondary inspection.
That's the back room.
Yes, the room where travelers are held for deeper questioning. And you will be informed that you do not have a valid visa to enter the United States.
Wait, so if I'm 1 day late, I can't just apologize and use that same visa for my next trip, and then they just put me on the next flight home.
Oh, it is much worse than that. Because you arrived at the U.S. border without a valid entry document, you are now subject to what is called expedited removal.
Expedited removal.
Yes. The CBP officer essentially acts as both prosecutor and judge. They can formally order you removed from the United States right there at the airport.
Just like that.
Just like that. And an expedited removal order carries an automatic mandatory 5-year ban from returning to the United States.
You're kidding.
I'm not. So, Your 3-day overstay just ballooned into a 5-year exile, complete with the trauma of being detained at the airport, having your visa physically canceled with a permanent marker, and being escorted onto a plane back home.
All because I didn't check the date on a digital document. I mean, that is a devastating chain reaction. But let's say I figure out my visa is voided before I book that flight. Let's say I'm sitting in my home country. I realize I overstayed by a few days last time. But can I just say, oops, I'll go to a friendly U.S. embassy in a neighboring country, maybe London or Paris when I'm traveling, explain the misunderstanding, and get a new one?
No, you can't. And this is the second highly intentional sting of Section 222G. Congress specifically designed this law to prevent what is known as consular shopping.
Consular shopping, what's that?
So before 1996, people who violated their visas would often travel to a third country, find a U.S. consulate with maybe a high approval rate or friendly staff, and apply for a new visa there. Section 222G stripped that loophole away entirely.
Oh, so they closed the door on that.
Completely shut. If your visa is voided for an overstay, the law mandates that you must return to your country of nationality to apply for any future U.S. visas. There are extremely, extremely rare exceptions for extraordinary circumstances, but as a rigid rule, you are locked into applying in your home country.
And why is the home country such a disadvantage in this scenario? I mean, shouldn't they know me better?
Well, because it forces you to face a consular officer who is tasked with evaluating your ties to your home country, but now you are stepping up to the window with a massive credibility deficit.
Right, because of the overstay.
Exactly. You are essentially saying, I know I broke the rules and overstayed the last time you trusted me, but please trust me again. And the officer is legally required under Section 214B of the law to presume that you intend to immigrate permanently unless you can prove otherwise.
Guilty until proven innocent.
Essentially, yes. An overstay on your record is the strongest possible evidence to the officer that you do not respect temporary boundaries. It makes obtaining a new visa incredibly difficult, even for genuine tourists.
So day one of an overstay is the silent trap door. Your visa falls through, 222G activates, and you are starting from zero in your home country with a permanently stained record.
Yep, that's the trapdoor.
But the research from attorney Chris Ingram's team separates that instant voiding from what happens next. Because the trapdoor is an event, but what follows is a ticking clock.
Exactly. It's a completely different mechanism.
Right. And this clock measures something called unlawful presence. So break down the mechanics of unlawful presence for us, because it sounds like it's distinct from the overstay itself.
It is vital to separate the two concepts. The overstay is the factual event of remaining past your authorized time. Unlawful presence is the legal status that begins accruing as a direct result of that event.
Okay, so how does it work?
Think of it like a taxi meter in a cab. Your authorized stay is the initial flat fare. The moment your I-94 expires, the meter clicks on and it starts charging you by the day. This is the unlawful presence clock.
The taximeter of doom.
Basically. And this clock is the engine that drives the most catastrophic penalties in the entire immigration system, the reentry bars.
Right, the 3-year and 10-year bars. Walk us through the specific math on this taximeter. When do the alarms actually go off?
Well, the statutes are entirely rigid. The first threshold is 180 days. If you accrue more than 180 days of unlawful presence, which is roughly 6 months, and then you leave the United States, you trigger a 3-year bar.
Meaning you can't come back for 3 years.
Right. You are legally forbidden from re-entering the country for 3 full years.
And the second threshold?
1 year. If your taximeter hits 365 days of unlawful presence and then you leave, you trigger a 10-year bar. A full decade of banishment from the United States.
Okay, let me push back on this on behalf of anyone listening who might be, caught in this web right now.
Yeah.
Because when we talk about laws, we assume there is some room for human nuance, right? Leniency for good people.
You would hope so.
Right,
I had a fantastic experience working with the law offices of Chris Ingram on my EB-1A petition. From start to finish, the team showed exceptional professionalism, clarity, and care. My caseworker, Yenny Ronchina, and case supervisor, Miguel Farias, were both incredibly thorough and knowledgeable. They took the time to understand the nuances of my case, guided me through the evidence preparation process, and answered every question I had with patience and confidence. I wholeheartedly recommend Chris Ingram's team to anyone navigating the complex U.S. immigration process. Their experience, integrity, and personal touch truly make a difference.
Let's say I was in a terrible car accident on day 175 of my trip. I'm in a coma, I wake up on day 185. I have crossed the 180-day threshold through absolutely no fault of my own. Does the system look at my medical records and say, okay, the clock is paused for the coma, you had a genuine emergency, you're still under 180 days?
I have to be completely direct here, because false hope is what leads people to make disastrous legal decisions. The unforgiving reality of the statute is that the unlawful presence clock has zero empathy. None.
None. Even for a coma?
None. It is a strictly mechanical counting of days. The system does not weigh your intent, it does not evaluate your moral character, and at the point of basic accrual, it does not pause for a coma. It simply checks a calendar.
Wow.
If you were physically present in the United States without authorization, the days count, period. The difference between leaving at day 179 versus day 181 is not a matter of paying an administrative late fee. It is the absolute difference between retaining your freedom to apply for a visa and hitting a solid 3-year brick wall of exile.
That is just brutal. I mean, it's so incredibly harsh. But it perfectly sets up the most counterintuitive, almost paradoxical part of this entire deep dive.
Yeah.
Because if I am listening to this and I realize I am at day 190 of unlawful presence, my absolute first instinct as a responsible adult is to stop the bleeding.
Exactly.
Right. The natural logical thought is, I have made a mistake, the clock is ticking, I need to pack my bags, buy a ticket, and leave the country immediately to sort this out from home.
It is the most natural human instinct in the world. You want to correct the error by removing yourself from the situation.
Right. So what does this all mean? If I realize I'm at day 185 and I pack my bags to be responsible and go home, my responsible action is the exact thing that locks me out.
Yes. If we connect this to the bigger picture, it is the single most misunderstood concept in immigration law. Let's look really closely at the language of the statute, INA Section 212B. It clearly states that the bar applies to an alien who has been unlawfully present in the United States for a period of more than 180 days, and who again seeks admission.
Wait, and who again seeks admission? Meaning they left.
Exactly. The trigger mechanism is the departure. While you remain continuously inside the United States, even if you have accrued 200 days or 400 days or 4,000 days of unlawful presence, the 3-year or 10-year bars have not technically activated yet.
They're hovering over you.
They are loaded, but the trigger hasn't been pulled. The physical act of crossing the border to leave flips the switch, drops the heavy iron gate, and locks you out.
That completely defies logic.
Yeah.
Why on earth did Congress write the law this way? It feels like it was designed as a trap to specifically catch well-meaning people.
To understand the why, we really have to look back at the legislative history. These bars were created in 1996 by a massive piece of legislation called the Illegal Immigration Reform and Immigrant Responsibility Act, usually called IRA.
Okay, 1996, what was the goal?
In 1996, Congress was highly focused on deterring circular migration. Basically, people who would come to the U.S. illegally, work for a few years, go back to their home country for the holidays, and then sneak back in. Congress wanted to punish that back and forth movement.
So they were aiming at people treating the border like a revolving door.
Exactly. So they created a penalty that activated precisely when someone tried to leave and come back.
But in aiming at that target, they inadvertently built a trap that catches everyone.
Everyone, including the person who accidentally misread their I-94, fell in love, married a U.S. citizen, and then decided to travel back to their home country to apply for their spousal green card the right way.
Oh, wow. Let's unpack that scenario right now,
Yeah.
because that is a massive revelation. If you marry a U.S. citizen, aren't you protected? Doesn't the overstay just get forgiven automatically?
This brings us to a fascinating and highly complex intersection of two different laws. There is a law, Section 245A of the INA, that allows certain people to adjust status to a permanent resident while remaining inside the United States.
Okay, adjust status. Got it.
Right. So if you entered the country legally with a visa and you later marry a U.S. citizen, the law generally forgives your unlawful presence if you apply to adjust status from within the U.S.
So because you never leave, the bar never triggers.
Exactly. Because you never leave, the 3 or 10-year bar never triggers. The unlawful presence is essentially washed away by the marriage to a citizen.
Okay, so stay inside the U.S., file the paperwork, and you are okay. But what happens if they try to do it from their home country? Because a lot of people think that's the more respectful way to do it.
It's total disaster. Let's say that same person, married to a U.S. citizen with 400 days of unlawful presence, decides, you know what, I want to have my green card interview at the U.S. Embassy in my home country so my parents can be there. Or maybe they just assume it will be faster.
Which is a totally normal thought process.
Right. But the moment they step on the airplane and depart the U.S., they trigger the 10-year bar. When they show up at the embassy in their home country for their spousal visa interview, the consular officer will look at them and say, "Congratulations on your marriage, but you are barred from entering the United States for a decade."
Oh my God.
Yes. By trying to do things the right way through consular processing, they triggered the very penalty that adjustment of status would have protected them from.
That is legitimately heartbreaking. It proves exactly why our attorneys insist, with absolute urgency, that no one who has accrued unlawful presence should make a move, and especially not the move of leaving the country without consulting a qualified immigration attorney.
It is the most critical advice we can give.
Because your intuition is practically weaponized against you. You need legal strategy, not instinct.
Absolutely. The moment you cross that 180-day threshold, the rules of common sense no longer apply. You are in a highly technical legal minefield, and every single step requires expert guidance.
To really solidify how these invisible mechanics operate in real life, let's bring in the composite case studies provided in the legal research. These are based on countless real-world scenarios our team has handled. Let's dive deep into the timeline of Sophia.
Yes, Sophia's case is the perfect illustration of how the system lacks empathy. So Sophia is a professional from Spain. She enters the U.S. on a B2 tourist visa to hike the Appalachian Trail. She does everything right.
Okay, a model traveler?
Exactly. She checks her I-94 at the airport, and she sees she has a 6-month admit until date. She plans a 3-month hike, so she has a massive margin of safety.
So she is fully aware of the rules. She's not like Marco, the other case study, who just misread his visa.
Right. Marco just confused the visa expiration for his stay. Sophia knew the difference. But 2 months into her trip, Sophia is in a devastating car accident. She sustains multiple fractures and requires emergency surgeries. She is in the hospital, heavily medicated, focused entirely on surviving and beginning physical therapy. The weeks turn into months. And while she is lying in a hospital bed, her 6-month I-94 admit until date quietly expires.
And the unlawful presence clock clicks on, the taximeter starts running.
Exactly. Now, let's look at what Sophia should have done versus what she did. What she did was focus on her health. She recovered, and 9 months after she arrived in the U.S., which means 3 months past her I-94 deadline, she was finally cleared to fly. She booked a ticket and went back to Spain.
Okay, let's do the math. She was over her date by about 90 days. So she didn't hit the 180-day mark for the 3-year bar, but she did trigger 222G.
Correct. Her visa was instantly voided the very day her I-94 expired, and because she accrued 90 days of unlawful presence, she's going to face a massive hurdle proving she won't overstay again when she applies for a new visa.
Well, wait, what was the alternative? She was in a hospital bed. How could she have prevented this?
This is where proactive legal strategy comes in. If Sophia, or maybe a family member acting on her behalf, had recognized the looming I-94 deadline, they could have filed a form called the I-539, Application to Extend Change Non-Immigrant Status.
Wait, you can request an extension of your tourist stay for medical reasons?
Yes, you can.
So you just mail in a form and you're safe?
Well, it requires deep documentation. You must provide a letter from the attending physician detailing the diagnosis, exactly why travel is physically impossible, and the estimated timeline for recovery. You also have to prove you have the financial means to pay for your extended stay in medical care without working illegally.
So it's a heavy application.
It is. But here's the magic of the I-539. If you file it before your I-94 expires, the government considers you to be in a period of authorized stay while the application is pending.
So it pauses the taximeter.
Exactly. It completely stops the unlawful presence clock from starting. Even if the government takes 6 months to process the application, Sophia wouldn't be accruing unlawful presence during that time. If she recovered and left before the application was even approved, she would leave with a clean record.
Wow.
But because she didn't know the mechanism existed, she suffered the penalty. Contrast that with Lucas and Elena, the other couple from the research. They checked their I-94 dates upon landing, saw they had less time than expected, and left with a comfortable margin.
It really emphasizes that knowledge is the only shield you have. But while we're on the subject of knowledge, we really have to talk about the bad knowledge out there, the misinformation.
Oh, there's so much of it.
The legal research takes time to systematically destroy 4 very specific, very dangerous myths that lead people directly into these traps. So let's tackle them. Myth number 1. My visa is valid for years, so I can stay for years.
We have thoroughly dismantled this one today, but it is the apex predator of immigration myths. The visa is the box office ticket. The I-94 is the usher's deadline. Never, ever confuse the two.
Myth number 2. A few days over doesn't really matter. The government has bigger fish to fry. They aren't coming after tourists who missed a flight.
This myth confuses enforcement priorities with statutory penalties. It is true that icy immigration and customs enforcement is not going to dispatch a tactical team to your hotel because your I-94 expired yesterday.
Right, they aren't kicking down the door.
They do indeed have bigger fish to fry regarding deportations. But the penalty doesn't rely on ICE finding you. The penalty is self-executing. A few days over instantly voids your visa under 222G. That requires zero effort from the government.
It just happens in the database.
Exactly. And those few days are permanently logged in the system, waiting to sabotage your next visa interview. Small overstays cause permanent administrative damage.
Okay, here's one I hear constantly. Myth number 3. If I overstay, all I have to do is marry a U.S. citizen, and it magically erases itself. It's the ultimate get-out-of-jail-free card.
This one is dangerously half-true, which makes it incredibly deceptive. We discussed Section 245A earlier, where marrying a U.S. citizen allows you to adjust status and forgives unlawful presence. But there is a massive condition attached to that law.
What's the condition?
You must have been inspected and admitted or paroled into the United States.
Meaning you had to enter legally through a border checkpoint in the first place.
Exactly. If you sneaked across the border without inspection, you are legally ineligible to adjust status inside the U.S., even if you marry a citizen.
So the marriage doesn't save you there.
No. You would be forced to leave the country to do consular processing, which, as we established, instantly triggers the 10-year bar.
Right, the trapdoor we talked about.
And even if you did enter legally, adjustment of status is a highly scrutinized, complex legal process. It involves intense background checks, financial affidavits, and interviews to prove the marriage is bona fide. It is never, ever an automatic get-out-of-jail-free card. Assuming it will just work out is a recipe for deportation.
And finally, myth number 4, the classic psychological denial. Nobody's actually tracking this. The U.S. is a massive country. I didn't scan my passport when I got on the plane to leave, so they don't know my departure date.
This is a relic of the 1990s. Today, it is entirely false. The U.S. government utilizes a massive database called ADIS, the Arrival and Departure Information System. They partner directly with commercial airlines.
So the airlines are telling on you.
Pretty much. When you check in for an international flight departing the U.S., the airline transmits your passenger manifest data directly to CBP. The system automatically reconciles your departure date against your I-94 admit until date.
And if the math doesn't add up,
if there is a discrepancy, the system flags it instantly. Nobody knocks on your door the day after you expire, but the algorithm remembers. It waits patiently for the next time you interact with the system, whether that's a visa renewal or arriving at a border checkpoint.
So the net is always there, and it is entirely digital. Now, up to this point, we have talked heavily about accidental mistakes, misreading a date, hitting a medical emergency, listening to bad advice. But we need to shift the tone drastically because the research from our attorneys also addresses a deliberate mistake. A mistake that takes an accidental tragedy and compounds it into the absolute harshest penalty in all of immigration law.
Yes. This is a very dark corner of the law.
Let's talk about the point of no return.
We must tread very carefully here, but anyone engaging with the U.S. immigration system needs to know this monster exists. We are talking about INA Section 212A9C, commonly known as the permanent bar.
The permanent bar. Just the name is chilling. What triggers a permanent lockout?
The permanent bar is triggered by a very specific combination of unlawful presence and deliberate circumvention of the law.
I am extremely pleased with the service and the help provided. My caseworker, Laura, was very helpful and willing to get on a call anytime. I am grateful for her help and would recommend the law office for immigration-related surveys.
Here is the scenario. A person accrues more than 1 year of unlawful presence in the United States.
Okay, so the taximeter ran for a full year.
Right. Then they leave, perhaps voluntarily, perhaps they are deported. They now have a 10-year bar.
A heavy penalty, but a finite one, 10 years.
Right. But 10 years is a long time, especially if you have family in the U.S. So instead of waiting out the 10 years or attempting to navigate the complex legal waiver process, this person decides to take matters into their own hands. They travel to the border and unlawfully sneak back into the United States without inspection. Or they use a fake passport to bypass the officer.
So they bypass the legal checkpoint entirely.
Exactly. The moment they attempt to enter or successfully enter without inspection after having already accrued a year of unlawful presence, they trigger Section 212A9.
The permanent bar.
Yes. The law punishes this specific combination of prior violation and subsequent unlawful entry with the harshest consequence available: a permanent lifetime ban from the United States.
So they take a bad situation, try to cheat the system, and end up permanently locked out. Is there literally no waiver for this? No way back at all?
It is draconian. Unlike the standard 3 or 10-year bars where you can immediately apply for an extreme hardship waiver, the permanent bar requires you to physically remain outside the United States for 10 full years before you are even allowed to ask for permission to return.
Wait, you have to wait 10 years just to ask?
Yes. You must wait a decade in exile, and only then can you file an I-212 form seeking consent to reapply for admission. And even then, it is highly discretionary. It is not guaranteed.
The stark takeaway for you listening is this. Never, ever try to solve an immigration problem with an unlawful entry. If you are facing a 10-year bar, that is a disaster, yes. But it is a manageable, finite disaster that a skilled attorney can work with. Trying to bypass the border takes a 10-year problem and locks the door permanently.
Precisely. You do not fix a legal immigration problem by breaking the law again. It is the absolute golden rule.
Well, let's pivot from the terrifying consequences to the hopeful, constructive side of attorney Chris Ingram's research. Because our mission today isn't just to scare you, it is to empower you with solutions.
Absolutely.
The law can't simply intend to separate a U.S. citizen from their spouse for a decade without any legal release valve. Right? If someone is listening right now and realizing they have crossed these lines, what are the actual avenues to fix it? Let's break down the tiered consequences and the pathways forward.
There are pathways, but they're highly technical. Let's start with the first tier, an overstay of under 180 days, where the person left before the 3-year bar activated.
Okay, so the taximeter didn't hit the threshold. They left on day 150. What is their path forward?
The good news is they are not subject to a statutory time bar. They can technically apply for a new visa immediately. The bad news is their old visa was voided by 222G, so they must apply in their home country. And they are facing a massive hurdle with the 214B presumption of immigrant intent.
All right, the consular officer is going to look at the screen and see a 150-day overstay. How do you overcome that?
Through overwhelming documented preparation. You cannot just walk in and say, "I promise I'll be good this time."
That won't work.
Definitely not. You must bring a meticulously crafted narrative explaining exactly why the overstay occurred, like Sophia bringing comprehensive hospital records, surgical reports, and letters from doctors. You must also bring dramatically stronger evidence of your ties to your home country than you needed the first time.
Like what kind of evidence?
Property deeds, a letter from an employer granting you a specific short leave of absence, financial investments. You have to actively rebuild the officer's trust from a severe deficit. It requires a strategic legal approach to consular processing.
Okay, what about the upper tiers? The 180 days triggering the 3-year bar and the 1 year plus triggering the 10-year bar. You can't just explain that away with property deeds.
No, you cannot. A standard visa application will be flatly denied based on the statutory bar. You have 2 choices: wait out the penalty outside the U.S. or seek a formal legal waiver.
Let's deep dive into these waivers. Because a waiver sounds like a magic wand, but given everything we've discussed, I know it's a brutal process. Let's talk about the Unlawful Presence Waiver, the I-601A. The I-601A Provisional Unlawful Presence Waiver is one of the most complex areas of immigration law. The statute recognizes that a rigid 10-year family separation can cause genuine injustice, so it provides a path for forgiveness. But here is the critical misconception that our attorneys want to clarify. This waiver is not granted because the situation is hard on you, the applicant who broke the rules.
Wait, it doesn't matter if I'm suffering in my home country.
Legally, your suffering is completely irrelevant to the waiver standard. The law states that you must prove that your absence from the United States would cause extreme hardship to a qualifying relative. And that qualifying relative can only be a U.S. citizen or lawful permanent resident spouse or parent.
A spouse or a parent. What about a child? If a parent is barred for 10 years, isn't that extreme hardship on their U.S. citizen child? This is one of the most heartbreaking discoveries for families navigating the system. For this specific unlawful presence waiver, hardship to a U.S. citizen child does not legally qualify you. The statute explicitly omits children.
How is that logically possible? The emotional and financial devastation to a child losing a parent for 10 years is unimaginable.
The legal rationale, as harsh as it sounds, is that the government assumes children are portable.
Portable?
Yes, portable. The assumption is that the child can either adapt to life without the parent in the U.S., or the child can relocate to the foreign country to be with the parent. The standard of extreme hardship is incredibly demanding. It means hardship well beyond the ordinary sadness, financial strain, and disruption of family separation. Ordinary hardship is expected and intended by the law as a penalty.
So what actually qualifies as extreme hardship to a spouse or parent? How do you prove it to a government adjudicator?
You prove it through an avalanche of expert evidence. You don't just write a letter saying, "I miss my husband." You provide clinical psychological evaluations diagnosing severe major depressive disorder or suicidal ideation resulting from the separation. You provide specialized medical records showing the U.S. citizen spouse has a chronic illness that requires treatment only available in the U.S., making relocation impossible, and requires the physical pair of the barred immigrant, making separation impossible.
It's an accumulation of extreme factors.
Exactly. You document severe financial ruin showing that the U.S. citizen spouse cannot afford to maintain two households across international borders and would lose their home. You document country conditions using State Department reports to prove that forcing the U.S. citizen spouse to relocate to the immigrant's home country would expose them to war, persecution, or profound economic deprivation.
That is massive.
Building an I-601A waiver is essentially building a massive documented thesis paper proving that the U.S. citizen's life will be fundamentally destroyed if the waiver is not granted. It requires months of preparation by a skilled attorney.
That is incredibly heavy. What if someone doesn't have a U.S. citizen spouse or parent? What if they just have a 10-year bar, but they are a vital executive who needs to attend a crucial business meeting in the U.S. or an academic invited to a conference? Do they have any options, or are they just locked out?
There is a different avenue for temporary visits, the non-immigrant waiver under INA Section 212D3. This is specifically for temporary non-immigrant visas like a B1 business visa or an H1B work visa. It is entirely discretionary. The government weighs three specific criteria, often called the Hronka factors, based on a famous case.
What are the factors?
1. The risk of harm to society, if you are admitted. 2. The seriousness of your prior immigration or criminal violations. And 3. The nature of your reason for wishing to enter the U.S.
So if your overstay was accidental, you have no criminal record, and your reason for entering is a highly lucrative business deal that benefits the U.S. economy, you have a strong argument.
Exactly. You aren't asking for a green card. You are asking for temporary permission to bypass the bar for a specific purpose. It is a highly effective tool when argued correctly by legal counsel.
Now, before we move off of pathways and safety nets, I want to highlight a crucial mechanism mentioned in the legal research, because this one specifically applies to visitors coming in under the visa waiver program. Let's talk about ESTER, the electronic system for travel authorization. And by the way, for anyone listening, that's ESTER. Read exactly like the name.
Yes, ESTER, a highly utilized system.
Millions of people from Europe, Australia, Japan, and other eligible countries use ESTER to pop over to the U.S. for 90 days without needing a formal visa interview at an embassy. But ESTER has a reputation for being rigid. If you are here on ESTER and an emergency hits like Sophia's car accident or a global pandemic that grounds all flights and your 90 days are up, you can't file an I-539 extension.
No, you cannot.
ESTER visitors are legally barred from extending or changing their status. Are they just doomed to accrue unlawful presence?
They are not doomed, but they must utilize a very specific, little-known mechanism called satisfactory departure.
Satisfactory departure, how does that work?
If an extreme emergency makes it physically impossible for an ESTER visitor to leave before their 90 days expire, they can request satisfactory departure from CBP, usually at a deferred inspection site or through USCIS.
Okay.
If granted, the government provides a grace period, typically up to 30 days. The true power of this mechanism is that if the visitor leaves within that 30-day grace period, it is legally recorded as a timely departure. It does not count as an overstay on their record, 222G is not triggered, and they remain eligible to use ESTER's system in the future.
That is a massive legal lifesaver. But there's a catch, right?
Yeah. The catch is timing and evidence. You must request satisfactory departure before your 90 days expire. You cannot wait until day 95 and ask for retroactive forgiveness. And you must bring airtight proof of the emergency canceled flight itineraries, letters from hospital administrators, proof that the delay is entirely out of your control.
The overarching caveat from our legal team regarding all of these pathways, the I-601A hardship waivers, the 212D non-immigrant waivers, satisfactory departure, is that every single one of these tools is highly technical.
I cannot emphasize this enough. The margin for error in these applications is zero. Reading a blog post and attempting to file a legal brief proving extreme hardship yourself is a recipe for a decade of family separation. You absolutely require an immigration attorney to navigate these specific avenues.
As we near the end of this incredibly deep dive, I want to bring the focus squarely back to you, the listener, and your immediate day-to-day actions. We've explored the trapdoors, the ticking clocks, the complex legal arguments, and the agonizing penalties. But the most hopeful takeaway from attorney Chris Ingram's research is that this entire nightmare is preventable with a few fundamental habits. Let's summarize the proactive, bulletproof habits that ensure these penalties never touch you.
Habit number 1 is the absolute foundation of your immigration health. Check your digital I-94 every single time you enter the United States.
Every single time.
Every time. Do not rely on the date the officer stamped in your passport, as handwriting can be illegible or incorrect. Log on to the official website, i94.cbp.dhs.gov, click on Get Most Recent I-94, enter your passport information, and verify the exact admit until date in the system.
Treat that date as sacred. Put it in your calendar. Set a digital reminder for 3 weeks before it expires. Plan your departure with a comfortable margin of safety.
Habit number 2. If your plans change, act early. Don't wait until the deadline is breathing down your neck.
Like we discussed with Sophia, if you realize you need to stay longer for medical reasons, or maybe you want to change from a tourist to a student to attend a university, there are legal mechanisms to do that.
But the protective rule is that the application, whether it's an I-539 to extend or change status, must be properly filed and received by the government before your I-94 admit until date expires.
The timing is everything.
It is. If you act proactively while you are still in valid status, the government essentially pauses the clock. You are in a period of authorized stay while they process your request, protecting you from unlawful presence. But if you file 1 day late, the protection is gone.
And habit number 3, which we must hammer home. Never ever trust a friend's advice on immigration timelines.
Well, please don't.
Your friend means well. Your friend might have overstayed by a month 10 years ago and says, nothing happened to me, it's fine. But your friend is not looking at your specific I-94. They don't know if you were admitted for a duration of status or a hard date. And they certainly don't understand the complex intersections of Section 222G and the unlawful presence bars.
A consultation with a qualified attorney to answer a basic timeline question is incredibly affordable, sometimes free. A problem discovered years later at a consular interview because you listened to confident misinformation from a relative is astronomically expensive in terms of legal fees, time, and emotional trauma. Trust the official statutes, and when in doubt, trust professional legal counsel.
We have covered a massive amount of conceptual and legal ground today, and I want to leave you with a final provocative thought to mull over. Of everything our team uncovered today, that your 10-year visa and your permitted stay are totally different legal concepts. That being a single day late instantly voids that visa by operation of law, or the mind-bending reality that the responsible act of leaving the country is actually the trigger that drops a 3 or 10-year bar on your head. Which piece of this invisible machine surprised you the most? Think about that one mechanism that made you stop and say, wow, I had no idea it worked like that. And I heavily encourage you, pass that specific piece of knowledge on to a traveling friend, a colleague, or a family member. It might literally save their future in the U.S.
And as we wrap up, we should note that we deliberately left one specific strategic thread hanging today.
We did.
We mentioned that if your plans change, you should file to extend or change your status to stay longer legally. But how exactly do you do that? What happens if you file an extension and it gets denied after your original I-94 has already expired? Does the unlawful presence clock apply retroactively? What are the hidden traps inside the I-539 process itself?
Leaving them wanting more. The mechanics never end.
Indeed. We will tease that as the exact topic of our next deep dive. We will explore how to transition from simply playing defense and avoiding an overstay to actively and lawfully extending your timeline in the United States.
I cannot wait to unpack that one. But for now, it is time to close the book on this deep dive. So let us leave you with the heart of it. Overstaying is serious, and we have not softened that because you deserve the truth. But it is also one of the most preventable problems in all of immigration, and it almost never happens to people who understand it. So remember the 3 things that keep you safe. Your I-94 admit until date, not your visa, is the real deadline for your stay. So check it the moment you arrive and treat it as sacred. If your plans change, act early while your status is still valid, never after the date has passed. And if you ever worry you have overstayed, do not rush to leave the country, because leaving can be the very act that triggers a years-long bar. Instead, get proper advice first. The strategies in this discussion are for educational purposes only. Your situation is unique, and the law offices of Chris M. Ingram are here to help you understand your specific options. If you're worried about your status or a date that has passed, please reach out before you do anything else. Visit breakthroughhepaze.com for a free consultation. Thank you for listening, and we will see you next time.